we aim to discuss, highlight, and dissect the rights-based implications of search and seizure, given the current legal landscape. It was only 20 days ago when Justice G.K. Ilantirayan of Madras High Court observed that the police action of seizing mobile phones of journalists in the guise of conducting investigation in a criminal case and forcing them to provide access to their personal data is nothing but an assault on the press and an attempt to oppress them. This order came in the wake of Chennai Press Club and individual journalists filing a batch of writ petitions. The writ petitioners who had been summoned for inquiry and whose mobile phones were seized by a special investigation team probing the Anna University sexual assault FIR leak case. While we have had orders and judgments coming from different high courts in Karnataka and Delhi, in 2023, there were a group of academicians who moved the Supreme Court of India, urging the Apex Court to devise model guidelines that would regulate search and seizure of electronic devices. What will eventually come out of these proceedings is something that we are yet to see, since the matter is still pending before the Supreme Court of India in the case of Ram Ramaswamy versus Union of India. Now, without further ado, it is my honor to introduce a distinguished panel of speakers for today's session. Firstly, we are joined by Professor Chirag Balyan, who is a founding faculty member at Maharashtra National Law University, Mumbai. He specializes in criminal law, with his focus areas being pre-trial detention and white-collar crimes. He has recently published 2 volumes on criminalization with Brill. Earlier, he edited Revisiting Reforms in the Criminal Justice System in Maharashtra, published by Thomson Reuters. Additionally, he has been involved in significant research projects, such as the report of recommendations for reforms in criminal law submitted to the Ministry of Home Affairs. His report, Commercial Sexual Exploitation in Maharashtra, a survey of public prosecutors, was published by the Ministry of Women and Child Development. Secondly, we have the fortune to be joined by, we have the fortune of Mr. Prabir Purkayastha joining us today, who is a founder editor of NewsClick.in, a website focusing on reporting people's movements and their voices. He's also the president and of the Free Software Movement of India, which works on building free software as a part of people's movements. He is also the author of Keeping Up the Good Fight, From the Emergency to the Present Day, Knowledge is Commons Toward Inclusive Science and Technology, and Enron Blowout, Corporate Capitalism and Theft of the Global Commons. Thirdly, we have the pleasure to host Dr. Colin Gonsalves, Senior Advocate at the Supreme Court of India and founder of Human Rights Law Network. Dr. Colin Gonsalves developed HRLN into a national organization and India's leading public interest law group, bringing together over 200 lawyers and paralegals operating out of 28 offices spread throughout India. He has brought numerous precedent-setting cases to the Supreme Court and the high courts of various states. Dr. Gonsalves has written, edited, and co-edited a number of articles and books on a range of human rights law issues. He was presented with the International Human Rights Award by the American Bar Association in 2005. And 2010, he was conferred an honorary doctorate by the University of Middlesex, UK. And finally, we have with us Mr. P.V. Dinesh, Senior Advocate at the Supreme Court of India with over 30 years of experience as an advocate. He is passionate about enhancing legal awareness and education in the country. This passion drove him to co-found LiveLaw.in, a leading online platform that provides timely and accurate legal news, analysis, and commentary to both the public and the legal fraternity. He is also the president and board trustee of SakshamKids.org, an organization dedicated to bringing education to the doorsteps of children of migrant workers and low-income families. Now, I'd humbly request our esteemed group of speakers to provide their opening statements on the topic. In the interest of time, I would request you all to take 3 minutes for the same. We'll first begin with Professor Chirag Balyan. Over to you.
Thank you, Pranay, for the nice introduction. Today we are dealing with search and seizure of electronic evidence. And the primary law which deals with this is Bharatiya Nagrik Suraksha Sanhita. We have Bharatiya Sakshi Adhiniyam and Information Technology Act. When Bharatiya Nagrik Suraksha Sanhita deals with this, it primarily caters to physical search, but it fails to distinguish between physical search versus online search. In the context of seizure, the search could be divided into two phases. First is physical seizure stage, wherein suspect computer is seized and taken to a police laboratory. And then there is electronic search stage, wherein forensic expert conduct a thorough examination of the seized device, often taking weeks or months. Our 105 of Bharatiya Nagrik Suraksha Sanhita says that search and seizure operation must be recorded by audio video electronic means. But if the search process in the context of digital devices is bifurcated into two phases, which the law fails to recognize, how does that happen? Because if there's a computer, if there's a device which is to be taken back to the laboratory, and thereafter forensic examination is the entire purpose of 105 or the regime of the law gets blurred. And thus, there are no fixed rules which exist on the scope of digital searches or how long law enforcement can retain seized computer. You have taken them to the laboratory, but how long will you retain them before returning them? And the absence of these time limits also lead to extended retention of suspect device without clear justification. Now, while physical search is one thing for the purpose of search and seizure, other thing is online search, wherein law enforcement may use malicious software, state Trojan, to access target device remotely, and this would enable authority to monitor activities in real time. You could collect stored data, including file messages and browsing history, and you could also activate the camera or microphone of the targeted device. Now, some people may mistake this with interception. Interception is one, and we could bring this within the regime of interception. But interception usually deals with communicable data which is being communicated between two individuals. But what about non-communicative data such as files, images, voice mails, which are stored in the device? That could also be subjected to the search by the law enforcement agency. And thus, on-site search, wherein you could conduct a specific location search, usually results into confiscation. In an online search, you would have a remote access to the data, even if the device is another country, and thereby leading into cross-border implication. Now, these uniqueness which digital evidence or electronic evidence bring has implication for individual privacy, has implication for the rights of the people involved. So how do we navigate them? Because say for an example, even say if we say 105 is an adequate regime, they are saying we will use the mobile phone of a person concerned, right? What if the battery gets drained at the right time? What if the memory is fulfilled? Thereafter, how many days you are supposed to keep recording in your mobile phone, right? Now, it's not a case that state is providing a device, right? It's the personal mobile phone of the police officer concerned you are using in order to see what is happening during the search and seizure operation, which I have otherwise argued is inadequate for the online searches as well as whenever the devices are taken to the laboratory. Then about if, say for an example, this recording is then transferred to the cloud or directly saved to the cloud, say for an example, police develop this kind of system, what are its implications again on the privacy rights of an individual? What happens during these searches and seizures usually? data of lot of third parties, which could be subjected to immunity, which could be subjected to, say, for an example, privilege. Also, law enforcement agencies get an access to, and those people never get an intimation that their data has been accessed or their data is at least in the possession of the law enforcement agencies, and thereby also affecting the rights of the third parties. So this is what I think in my short comment, the present situation of the regime of search and seizure. We'll look forward to much more detailed comments when the time comes.
Thank you. Thank you for that, Professor Balyan. Now I'd like to invite Mr. Prabir Purkayastha over to you, sir, for your initial thoughts.
I feel a little bit of a misfit talking over here because I'm really now in the midst of the legal professions, professors, and so on. So I must say that it is quite intimidating to speak about law with other, professionals or in law. So I'm going to make a very brief couple of points. A is that the devices which are used, and I'm not talking about what is the law and so on at the moment. I'm simply talking about what is happening, is that once these devices are seized, they go into what are called forensic laboratories of the police. And those forensic laboratories claim, because the police have seized so many devices, that they are not in a position to examine these devices till after X number of months, maybe even a couple of years. Now, therefore, what you are doing is effectively putting critical equipment of the organization, of the journalist, in a cold storage. And effectively, this is for an organization, this is capital goods, because that's what a digital platform uses for its production of news. And of course, for the journalist, it's an attack on his professional right to practice journalism. That he today, without a phone, which also serves for him as a recording device, as also as a camera, because journalists are also doing videos using phones. And effectively, as you know, a good phone, really powerful phone, is as good as a video camera. In fact, some of the television companies use routinely cell phones, what are called cell phones, in lieu of cameras, because they're actually not only equally good, they have certain features which make it very easy to record things in real time, particularly when you're moving. It's not a studio scenario. So you are really depriving people of their ability to practice their profession by taking away equipment which they need for their professional lives. So I think that's a very important issue that is there. And if multiple agencies come for the same thing, which they do, then I have at the moment 5 agencies which are investigating NewsClick Me and so on. Now, you can have repeated seizures of your equipment, not one, but multiple seizures. So you replenish say that you get a new phone, a new laptop, and you start working, it's again seized. And it is not that it happens to only people like me. It happens to my working journalists who are using it for their professional purposes, who, even if NewsClick is not able to pay their salaries, could do other work. They're not able to do that work too. And I think the number of devices seized by the special cell, for example, in my case, and this is a matter of record, so I'm not giving any privileged police information out, is I think in the order of 380. Of course, that includes cell phones, cameras, hard disks, and various other things as well. But the number is 380. So for professionals who lose their phones, who lose their jobs because the company shut down, their salaries cannot be paid, they also have lost their ability to practice their livelihood. And I think that's the other aspect I want to bring out, in addition to the privacy issues, which has already been brought out. So I'm not going to repeat that. What is my right to privacy? And also, I'm not getting into the issue, does the state have the right in terms of in so-called interception mode to essentially hack our devices. And hacking cannot be considered as interception. It is going beyond what the law should allow. If you're allowed to hack a phone, it's a malicious intervention in my device. And I think that is not covered under any criminal law that we have, that the state has a right to hack. I don't think that is a right which can be protected under law, but I'm open to correction on this. As I said, that's a disadvantage of speaking amongst lawyers and talking about law. So I'll end here and leave the field for others who probably know much better about the issues than I do. And I hope that the Supreme Court will not put the privacy issue which the journalists have taken up before the court, Ramaswamy's plea, in which we are also a party. NewsClick is also a party too. And hopefully these hearings will take place to clarify what the law is and what, as a journalist, what my rights are.
Thank you. Thank you so much for that. So I think in your opening statements, you highlighted two very key issues with given the current legal landscape that we have. So thank you so much for that. I'll next request Dr. Colin Gonsalves to share his opening remarks. Over to you, sir.
Yeah. Well, Prabir, sometimes we lawyers are intimidated by journalists like you, who so quickly point out to myriad faults in our legal system. We think in traditional ways often. We think in, ways that are like a lecture in a class and so on. But when we hear you in the short span of 5 minutes, you threw up at least about 3 or 4 major issues relating to the law, relating to search and seizure. We need to think out of the box completely and not worry about, presentations and so on, but we really need to think out of the box. And I think many of the things that the journalists have gone through is a good starting point. Because if we can't, as lawyers, if we can't stop the rot that is happening to journalists and the things that Prabir mentioned, then what are we good at, really? I want to raise just 2 issues at the moment where we need to think in a very different and fresh way. It has been a very long-standing line of judgments which say that even if the search is illegal, the evidence is admissible. Fruit of the poisonous tree, as they say. Now, America stopped that. If your search is illegal, your evidence is discarded. But this judgment, going back to the Privy Council period, is to be found again and again and again. Now, it has awesome consequences, and this is something we need to reverse. We must have a plan of action to reverse. Because if I take your phone, and if a phone is part of your, illegal search, I can take your phone, and it's illegal, let's say, but I can intercept it, take out the material, and use it. It's admissible in evidence. Such a shocking thing, isn't it? It's an illegal search, but you can use everything. All the data that you get is perfect. So that's one issue we need to look at and have a plan of action for setting aside well-known precedents that are actually totally rotten. The second is right to silence. Nandini Satpathy's case. Again, you go back to Miranda in the United States. You have to tell a person that you have a right to remain silent. But in India, if you don't answer questions of the police, you are prosecuted again. Why should there not be a right to silence when Article 20, sub-Article 3 gives you a right against self-incrimination? Why can't I say as a journalist, I'm sorry, sir, I'm not answering your question. And if I'm not answering my question, my mobile is not answering your question either. I'm resisting your search of my mobile. I'm not going to give it to you. I'm not giving you my laptop. I'm not giving you my mobile. I'm not giving you anything, and I'm going to remain silent. And I say these, I'm giving you 2 points because we need to have a more aggressive approach in law on these issues. Because I saw, for example, in one case, Prabir, was that your case where the court said, give us suggestions for journalists' phones and so on. And I saw the recommendations made, and I was a little taken aback because of its, it's so collaborative, if you like. Get a judicial warrant and then you can take my phone. Any idiot of a judge will give you a warrant to get your phone. I don't want to give you my phone. I don't care for your warrant. I have a right. I'll not give you my phone. So that's what I want to say as a start.
Thank you so much for that, Dr. Colin. I will finally now invite Senior Advocate P.V. Dinesh to share his opening thoughts on this topic.
Thank you for inviting. I take strong exception to Prabir's statement that he's a misfit. He's the right person to answer all these questions because he's a person who has undergone incarceration twice during emergency and during recent times. So he has got the first person account how the system is being abused. So the question is, the present day scenario is the sad reality of our democracy, how it functions, because we are going through an undeclared emergency. So this is the situation now. So even if you have all the laws, you look at all the laws, because the basic essential fight or essential issue we are facing is the violation of human rights, and not from certain parties on the part of the state. And state has been given a lot of leverage. You take all these laws, all the rules, BSA, everywhere, in exceptional circumstances. So these exceptional circumstances, it is not defined. You don't need a search warrant for that reason. You can search any person. So what happens is the fundamental principle of criminal law is that you should investigate a case, you should investigate the case, not an offender. But here what happens is the reverse thing is happening. You are investigating an accused person or a person who is accused of an offense. He is being investigated. In that rowing inquiry, you are trying to get whatever relevant, whatever irrelevant, and they try to leak this information because the mobile phone, we all know that mobile phone is basically a person himself because it contains everything. These days the mobile phone is basically a key to a person. It's as equal to as brain of a person. And it's not the case that a person himself is implicated. A person is subject to blackmail because a person may have all kinds of relationships. He might be, suppose in a case of a journalist, he might be having a source. The source may not be interested to disclose. A person may not be interested to disclose the source. But when you open up the mobile, that person is also in danger. So apart from the person who is being investigated, you are effectively investigating multiple persons in that ecosystem and creating a web of threat among those persons. And socially, how a person can be completely destroyed. It's only socially a person, apart from the legal cases, a selective leaks. We have recently seen that WhatsApp messages leaks. Unfortunately, our courts are not taking it very seriously. It is not shocking the conscience of the court. The mobile phone is seized. They see it very lightly. Okay, next date. And after years only, I think 5 writ petitions are pending before the Supreme Court. And this search and seizure is happening every day in our country. And this is an important issue, because the early days of investigation is over. Now everything is based on digital investigation, forensic examination. So there should be a proper setup, proper guidelines immediately. which can be implemented. We have got a lot of guidelines. We have seen the NDPS Act, this Narcotics, Drugs and Psychotropic Offence Act. In this section 50 talks about a search by, suppose if the police is searching a person who is accused of carrying certain narcotic substance, psychotropic substance, a person has got a right to be searched by a gazetted officer or a magistrate. The police will ask this question and the police will make a record. We ask the person, do you want to be searched by so-and-so, so-and-so? They themselves make a report. The person refused. Person said, I don't want to be searched by so-and-so, so-and-so person. And search is carried out. All the police people are signing the search master. So this is happening. So unless we strengthen our democracy, see, we might be having enough laws. Laws are not enough. We have to see that these laws are implemented in letter and spirit. So for that purpose, we need to create some sort of a movement, not only the legal cases, we need to create awareness in the society. Then only this problem can be solved, not by any number of laws or rules or regulations.
Thank you so much, sir, for highlighting the need, not just for guidelines on this particular topic, but also a movement and how this impacts democratic governance. Now, starting with the discussion, Professor Balyan had highlighted how a physical search, the aspect of a physical search is very different from that of an online search. Now, keeping that in mind, we had the older criminal legal regime within the IPC, CRPC, and the Indian Evidence Act that did not address many of these procedural and substantive legalities when it comes to collecting, storing electronic evidence during investigations. Now, how do you see such gaps in law affect the ground reality of this particular process of search and seizure? And I would first invite Professor Balyan to respond to this.
See, as Mr. Dinesh rightly pointed out, there are two primary issues. One is absence of law, and second is absence of enforcement. Every law we have, for that we have an alternative, an exception, that something could be done by the police investigation out of their prerogative, out of their discretion. That's point number one. Point number two, our legal regime on search and seizure of electronic evidence is not just inadequate, it is absent. Because you can't just simply supplant the principle of search and seizure of a physical place with an electronic device. You're collecting so much of data, when you're processing so much of data, how do you process this data? Where are the guidelines? How do you sort this data? How does a judicial warrant, say for an example, it could be very specific in terms of search and seizure that you should look at a particular almirah or container in which you must find the evidence. How do you find that in the context of an electronic device? How do you specify which folder, which file should be searched? Okay, for example, you have been able to do that. What if the file is encrypted? How do you do that? Now, then the enforcement agency would go back and say, the files are encrypted and I'm not able to access them. The major intervention in this regard has been made by this Karnataka High Court judgment of Virender Khanna, wherein certain guidelines have been laid down where the person concerned refused to give the thumbprint or whatever the mobile password, and the court directed that you should give the mobile password, and in the process laid down many guidelines. Now, to some extent, those guidelines are good, but do not still answer the gap question which you are trying to ask, right? Say for an example, those guidelines, earlier Mr. Prabir was saying, there cannot be, what we say, malware use or some kind of forced entry into mobile phone. judgment in this Khanna judgment, High Court has categorically said IT Act permits this. They can forcibly enter your mobile phone if you refuse to give your consent. So on one side, they would say that technically the permission of the person should be taken. On the other side, they rely on judgments like Kathukali Oghad, wherein they said this is just a mechanical thing. And because your thumbprint, your password is mechanical, it does not fall under the ambit of testimonial compulsion. And you should also give the password. But if you refuse to give password, then the same could be extracted. Your device could be, your password could be broken. And not just that, right? It doesn't stop that. Even after that, say for an example, you could change the password as an enforcement agency so as to refuse the access to the owner. That's point number one. Then subsequently, what happens in these kind of cases, because you have kept the device, as Mr. Prabir mentioned, for a longer period, right? Law, whatever country law you mention, and not just Indian law, they haven't specified for how many days, how many months you can keep this device. How this device will be utilized during this particular point of time. Now, one particular suggestion to fill this gap, they are saying that do a keyword search. In a search warrant, make a specific that when you're entering the system, when you're entering the device, use the keyword search. But how good even a keyword search is in the context of electronic device, how a judge could preempt what kind of keyword will be required in order to search the device. And thus, my argument that the question of gaps only arise when there is a legal regime. At the present time, the legal regime is absent, and we are just working on ad hoc whims and fancies of the enforcement agencies and judiciary, the courts which are ratifying, doing an oversight function, they are mechanically approving these orders.
Thank you so much, Professor Balyan. I would now ask Dr. Colin for his response on this question.
It may turn out to be in the days to come that the judiciary, which once defended our rights under search and seizure, will be the main culprits actually supporting police actions in search and seizures. Looks like it. And particularly since about 50% of our judiciary is saffronized, I think judicial orders directing you to submit your mobiles and passwords and so on will all be very commonplace. I know our young lawyers love to talk about Puttaswamy and the right to privacy. But the judiciary has a very strange way of delivering judgments, full of flowery words and flowery language, which young students catch on. And many journalists catch on and talk about a breakthrough by the judiciary, not noticing that there's a sting in the tail of judgments. And so surrounding and camouflaging the real intent and the real nasty words in the judgment, you have all this flowery stuff. On search and seizures, you can be beaten to pulp and you can have your house invaded, have your books checked, have your almirah, if you like, opened, and whatever is seized by a totally unlawful search, like I said, is perfectly admissible in evidence. Now, why should that be? And I think we need to focus on the large strategies and not get caught up so much in too much nitty-gritty so that we forget the big picture. Now look at videography, which is in certain sections applauded as being a step towards transparency. Videography of 161 statements, videography of search and seizures. this videography thing will turn out to be the biggest setback for a fair trial. I saw Afzal Guru. Afzal Guru, I'm giving you a kind of a not very direct example. Afzal Guru was seen by the nation telling the nation that he participated in the attack on Parliament and was responsible for getting the explosives and the accommodation for the so-called terrorism. But if a person was present where that video recording was done, you would see that his hands and legs were tied to the chair on which he was sitting, and surrounding him was a large number of police people watching the drama. But the camera focused on his face. And I know there were judges of the Supreme Court who ultimately heard his case, very convinced that they heard him speak voluntarily, because the camera didn't catch anything more than his face. Search and seizure, so easy. Your camera is not a revolving camera. It'll focus at a particular person. And what happens behind when they plant certain things in your room at the same time as they are video recording, and then the camera will take to, oh, here we found something in his house, and you're dead. You see, any suggestion made by government, you must automatically know it's a rotten suggestion. Inherent suspicion of the police and of the drafting of legislation and so on. I'm just doing a case from Guwahati, a fake encounter case, where the boys who were supposed to have come with arms and ammunition and were intercepted by the Assamese police, they had the video recording ready. It helped me because they didn't know that, it had been circulated. It helped me because I could show that when they got out of that little auto rickshaw where they were supposed to carry AK-47s, there was nothing. They were searched, there was nothing. But then there was a larger video prepared, which has now surfaced, where the police opens a bag, same auto rickshaw scenario, puts his hand in it. There's obviously no pistol in the bag. And then he runs, pistol, 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 pistol. It's like a videotape of a small little movie. And the officer said, okay, camera, ready, shoot. And that's how they fabricate that we found a pistol in his bag, and this is our video to prove. So we'll really need to look at, not only videography, also, what I said earlier, namely that if it's an illegal search, everything goes, and the right to silence. Just to repeat, we must get the right to silence, which was given to Nandini Satpathi's case. I can keep silent. Can't do a thing to me. 23 is the prohibition against self-incrimination. I refuse to speak. I refuse to give you my mobile. That's it.
Thank you. Thank you so much, Dr. Colin. I think in your response, you very well highlighted how the status essentially of how right to self-incrimination is completely diluted. And Professor Chirag Balyan also spoke on how there are multiple avenues in which search and seizure can be carried out without warrant, and how there is an absence of legality. Senior Advocate Dinesh, what is your response to essentially on what the prevailing gaps are within the current law? You're on mute, sir.
Dr. Colin talked about videography. Videography is a double-edged sword. Okay. See, suppose if you have a body cam, those party who is the party or the police officers who are coming to your place, and they have all the body cams like in other Western countries. Each and every moment is captured, because what happens is, of course, we have. I'm not a technical expert, but we have the system of hash value, or providing what really you are looking for. Suppose you have some evidence, a piece of evidence, and you are suspecting. So you are getting a search warrant, or exceptional circumstances without a search warrant, you are going to a person's place and searching for electronic. We are discussing only electronic devices here, electronic gadgets. So you are looking for an electronic device. So what are you, in that case, there should be a uniform standard, because we know that there are a lot of central agencies, and law and order is a state subject. So state police, they're all involved in this search and seizure. So in a country like ours, there should be some sort of a consensus, an uniform guideline, how this search and seizure of electronic devices should be conducted. But unfortunately, even after, for example, this Sudha Bharadwaj and Professor Navalekar, they moved an application for clone copies of whatever seized from them. Because whatever you have seized, if you can at least provide clone copies of those forensic material, which they claim to be an evidence against you, at least we will also come to know, the accused will also come to know what is the evidence against us. But nothing is happening. And whenever this issue is taken up to the higher courts, the courts are very slow in their approach. So unless this issue, the judges are sensitized, and there is a movement. Of course, you started this. This is just because of the court orders, it is not going to happen. Or central government, there is no question of sensitizing the central government, or for that matter, any state government. Because state, whatever may be the color of the state government, whichever may be the political party controlling the state government, the police as a same character, whether it is ruling party, whether it is opposite party, police has a certain characters. Police doesn't want to give up their rights, and they give up their rights so far as, and we don't have the concept of ethical search, nothing of that sort. Evidence is, most of the time, they create evidence. If there is no evidence good enough to convict a person or fix a person, you can very easily create evidence. So in that case, what is possible to do? For that purpose, I think there should be a countrywide consultation process from civil society and address this issue. And we should campaign for uniform guidelines, and there should also be a central impartial authority to look into and verify. Like, in the case of a the preventive detention case, there is a board to look into whether the preventive detention, the procedure is complied or not. Preventive detention is good or bad. So there should be an independent authority to see whether the search conducted is as per the guidelines issued by this common consensus, not by the courts alone. Because the courts, what is happening in courts, central government will be giving certain suggestions. 5-6 lawyers who are appearing for different parties, they will also be giving certain suggestions. Judges will be consulting with law clerks, their own opinion. They will come out with a guideline, and that is going to be the law of the land. That's not good enough. There are a lot of technicians in our country. We know how the system is hacked. Even if you have all the guidelines in the world, still there are enough measures to breach this guidelines, regulations, rules. So we should work for a foolproof system protecting the privacy of persons, and at the same time how this arbitrary action can be prevented. Because we are not much bothered about the civil disputes, or we are not much bothered about the hardened criminals, a person who is who is involved in multiple cases or multiple cases of terrorist activities or whatever activities. We are not worried about it. Our worry is mostly concerned about opposition, whether it is central government or state government, opposition political party leaders, social activists, journalists who are in receipt of certain privileged communications. So how to protect these people? Those people who are, if I am leader of an opposition political parties, I have every democratic right to fight against the government and certain policies of the government. I myself can't do that. I have to create a movement. I'll be speaking to various persons. Those persons may be against the government. So I need to have a movement. I need to create a movement, and the government will be portraying it as a move against the nation. They are not treating it as a democratic right of a citizen to fight against the bad policies of the government. They treat it as a movement against the state per se. So unless we create such sort of a momentum in our country, such sort of a movement, I don't think that any number of all these safeguards will be just on a paper, can't be implemented at all.
No, thank you for that. So and as senior advocate Dinesh mentioned, privileged communications. Prabir sir, I would like to come to you and essentially ask you from your experience, in what ways are electronic devices crucial for effective journalistic work? And I request you to highlight the ground level realities of using such devices in modern day journalism, how
Let me
this impacts a lot of rights. Yeah.
Let me first start by saying I think the point that has been made, and different people have made it already, is that ultimately it is not the law that gives us the rights. Ultimately, it's people and the people's movements which are required to protect the rights of the people. And that's what we saw post-emergency. When Mrs. Gandhi had declared emergency, it was really people who asserted democracy in the country and defeated her in the elections and taught her a lesson, which she learned, not that she didn't. I don't think this government wants to learn any lessons, and our task of teaching this government has also become relatively more difficult today. I'm going to leave it at that. Coming back to what you asked me, that what is the role of electronic devices today? Not simply as repositories of information, but as tools for production of journalism. We today do not print a newspaper. We actually publish videos and we publish written material, basically because we have a tool for production of this, either the computer or by cell phone. Both are in effect tools of production. And for platforms like NewsClick, which are digital platforms, we have actually more elaborate, more expensive tools for not only doing it in real time, but also collecting huge amounts of material, which we have done in the past. All the videos of past movements was with NewsClick. Where was it? It is on a repository, which is expensive, but which was backed. It had what is called triple backups, which were there. Now, if that whole system is dismantled and taken away to a forensic laboratory for an indefinite time, by the time we get it back, it's not going to be worth anything, is beside the point. But I have lost the ability to produce news. I have lost the ability to produce videos. And that is really like taking the printing press away from a newspaper. Now, just cutting the electricity to the newspaper during emergency produced later on a pushback. But what happens when you take away the tools of production, not just repositories of information, but tools of production from journalists and journalist organization? I think is one of the issues the journalists' body have to lead on this. And that is something that we all have to see how it can be done, because this is not simply how I should not incriminate myself. What are my digital rights, which I think are very important, well beyond what journalists are talking about. But as journalists who have certain basic right to their profession, does it entail also protecting the devices which produce what I finally live off, which is my profession? And I think that is something which is the right to practice my profession is taken away if my devices are taken away, is something which I think is an interesting point that should also enter the debate. And what others have said, I really have nothing more to add. They've said it much better than I would. So, and that's why I said I endorse that only movements can protect rights. Law only protects if the people are willing to assert themselves and assert their rights in public sphere. And that really is the task before us. These are not esoteric rights. They are rights which are fundamental to a democracy. And I think that's what needs to be brought to the people so they feel that they are a part of what is happening and they need to assert their rights on our behalf as well.
Thank you so much, sir, for earmarking essentially how what are the implications of this process on democratic governance. I would also like you to sort of speak on how, as you had mentioned earlier when you were responding to the question, how the process took an indefinite amount of time. If you could briefly touch upon from your experience how the search and seizure process sort of presents itself in a practical way, because the law says something, but often the reality goes the other way. So if you could sort of speak to that, that would be really great.
You're asking me?
Yes, sir.
Okay. Well, some of this is I'm out on bail. So the how much I can or should speak about my case itself is open to question. Simply put, when enforcement directorate was in my house, for example, I think they spent about almost 5 days in my house. Okay, I think it's the longest raid conducted in a private premise, except the one I think conducted on Amber Fort, which was 10 square kilometers in area against three bedroom flat that I have. Okay, but it was really trying to download my data from my Gmail account. So that's what took the time. So these are laughable at one level, but at the same time, of course, the invasion that takes place is suffered not by us as journalists, but anybody who's investigated in the country today. That's why I'm sort of leaving that angle out, because it's not something that only is a matter of the media. But I think what differentiates what we have from others, one is that we collect information for informing the people at large. Therefore, what we do as a profession is intrinsic to democracy. Second is technology today is such that information repositories and tools of production are the same. And I think that is something that we have failed to tell the people, that you are not talking about dead information which is lying and the police are collecting, but you are taking away live means of production of what we do as a profession, either write or do videos. And I think those things I wanted to place before, particularly since this is an august body of lawyers, people like uh, uh, sitting here who have been in courts so many times, Colin, for example, and others, that if they look at these dimensions, then I'm sure our struggle will be enriched. And ultimately, the real issue is not us. The real issue is, who are we doing it in our behalf? Who are doing it for? And here, the issue for all of us is the people of this country who have to protect their rights and our rights.
Thank you so much for that, sir. And sort of taking away from that, we have talked about how briefly we have talked about how the legalities of this process translates itself, and also the reality of it in terms of how it's conducted. Given the current gaps that we have discussed about previously, what changes would you like to see in terms of safeguards to ensure a balance between effective law enforcement and safety of user data and devices, keeping in mind jurisprudence that we have? And I will invite Professor Balyan and Senior Advocate Dinesh to respond to this.
May I proceed first, Mr. Dinesh?
I'm sorry.
No, he took both of our names. I was taking your permission.
No, you
Can
please
I go
continue.
first?
You please go ahead, please.
Yes. So, Pranay, as far as this question is concerned, I'm going to take few best practices from around the world. There's this European Court of Human Rights case called Big Brother Watch case, wherein European Court emphasized that judges have detailed course of investigation, and they must understand the purpose of probe to evaluate the necessity and proportionality of bulk data perception. So this is one very important thing, because either police or prosecution could very selectively give the records and evidences to the judge, and accordingly judicial oversight could become redundant or non-effective. Second most important thing which emerges from EU regime is that known suspects should be notified and given the right to challenge data collection. I think this is very important for privacy. Then there is something called in Brazilian constitution, because many constitutions, in order to defend these rights, have also amended them. One of them is Brazilian constitution, which recognizes something called as we call habeas corpus, habeas data. And this habeas data grants individual the right to know what data is held by public agencies, and it also allows correction or deletion of incorrect information. I think this is something we can kind of consider in our legal regime also. Then what we could say, for an example, again from the Brazilian constitution, they have a constitutional right in terms of secrecy of correspondence and communication, and the access is allowed only with judicial authorization. Furthermore, by their 22 amendment, they have also established a fundamental right to personal data protection, including digital data. So that's something we could look at. I'm not sure how it would go, how it would further. The next important thing probably we could learn from one of the German case laws. There's the German Federal Constitutional Court of 2008, which said digital search must have a clear legal basis. It should be allowed in exceptional case like life, public safety, national security. Apart from that, there shouldn't be digital search. The judge must authorize on the basis of proportionality principle. Key conditions which were laid down in this case were digital search must relate to serious crime. There should not be any other alternative investigative method. Lack of alternative is very important. Then surveillance software must have security mechanism to protect data, whatever surveillance software they are using, and collected data must be preserved properly for legal evidence. Likewise, Italy also reformed in 2010, and they made their changes based on Budapest Convention on Privacy. And their primary focus was preserving data integrity and ensuring no alteration or loss during evidence collection. So these are some of the regimes we could look at. As far as approach is concerned, there is one approach called triage model, which basically is necessary to determine what data to collect while adhering to legal standard, because any kind of search and seizure operation, as we all know, must maintain a delicate balance between individual liberty and the state interest, right? And this model has 4 key steps. First is planning. How do you identify relevant data within legal limits? And that must be clearly mentioned in your written reasons, which usually you should make for such operations, so that could be assessed by court or the monitoring authority. So there should be planning. There should be something called execution. Execution in terms of applied techniques like extension-based sorting, keyword filtering, and timeline analysis. So if the crime has been committed, say for an example, allegation is 2019 to 22, why do you want to analyze the data from like whatever, before or after that? Then you need to categorize the data in terms of relevant data, irrelevant data, external sources, new investigation leads, and accordingly take a decision as to collect, discard, or request additional warrant for specified data. So this is a triage model which has been suggested by some scholars to make sure that there is a balanced. Furthermore, there have been suggestions that authorities must delete irrelevant data. Whatever data is not necessary for the case, it must be immediately deleted and should be kept in their system. So these are some of the suggestions from my side. Thank you.
Thank you so much, Professor Balyan. Senior Advocate Dinesh, I would invite you to respond to that.
Yes.
Yeah, thank you.
We discussed so many things. Of course, we slightly digress from the core legal issues, because core legal issues such as 61, 62, 63 of BSA, or 105 and 185 of BNSS, etc. That should be everybody, whoever is watching this show, should go into in depth of these provisions and understand the consequences of it. And when compared to the old regime, so far as what is happening around the world, so far as those people who are watching are concerned. But the primary concern is basically identification, collection, preservation, analysis, and admissibility of this data, basically the electronic or digital evidence for that matter. And the most important aspect is, as mentioned, the proportionality and the chain of custody of this digital data. And there should also be, the chain of custody should be very specifically mentioned, who is handling this. We don't have sufficient infrastructure. Say 105 talks about photography, but we don't have a system of keeping all these files, video files with a large quantity, with large data. We don't have the system in our codes, etc. So there should be a proper system to address this. What best, as part of the civil society or lawyers are concerned, or those people who are in the movement, we should do a lot more research on this, make suggestions in a very crystallized form, educate our judges, basically, whoever is here in the matter. That should not be between Government of India or few states and 5-6 lawyers. There should be a discussion among the members of the civil society, and we should come out with comparing such situation, because we have much advanced system is there around the world. So we should compare all this and present in a very systematic manner as a document before the court, whoever is filing it, because anyway, the court is going to consider this issue, and the government is not going to come out with any guideline. Even if at all government is going to come out with some sort of a guideline, that will always be supporting the government power in search and seizure. So for on the so far as civil society is concerned, we should come out with some sort of a proper document which should be circulated among all the lawyers, civil society members, and we should also file it as a document before the court, so that court can seize of the issue. Because we can't blame judges sometimes. Judges are also not technocrats. Judges are also relying upon the whatever presented before them. Otherwise, judges should be so proactive. That may not happen in our present circumstances. So what we should do is, as I said earlier, we should have a robust system to address this issue, which is our responsibility, not state's responsibility or court's responsibility.
Yes, thank you so much for that. So now I'd like to invite Ms. Mishi Chaudhary, founder of SFLC.in and Senior Vice President and General Counsel at Virtue, to announce the launch of the guide and briefly address the audience. Over to you, Mishi. Thank you.
Thanks, Pranay, and thank you to all of you. It's been an immense pleasure to just listen to you and also to engage on the matter. Prabir has left right now because he had another engagement. I know all of you also have other engagements. I do want to say is that October 3rd, 2023, as he was getting arrested and we were all watching, there was a lot of discussion about search and seizure of digital devices. That's the time we started to think about what happens when someone who is a regular person does not have access to all the kind of infrastructure which perhaps a journalist might have or may not have, or a knowledge about what their rights are. And that's when we started to think about and go deeper and deeper into our surveillance and privacy related work. And we figured out that there obviously is a lack of a lot of understanding, knowledge, what our rights are. It is typical of our Indian governments, no matter who is in power, that sweeping laws are enacted, but then carve-outs and state exceptions are made in the same law. Whether you see the DPDP Act, which is about which was going to solve all our data protection and right to privacy issues, the kind of exemptions the state has, or the various other legislation under which the state who exercises their power through various agencies, including the police at the state level, but also centralized agencies, have exemptions, and then those rights get impacted. SFLC worked on this guide on search and seizure of electronic devices. You will see that this is on the screen right now. We're launching the guide. It is mostly for everyday people. I think all the speakers, Prabir, Dinesh, Dr. Colin, and Dr. Chirag, you all made the point about people need to feel their own power. Many a times we can have laws and they may not be implemented. Several times they don't exist. There isn't an equivalent of a Riley or a Carpenter or a Fourth Amendment like the one exists in the US. When in the absence of such things, the first thing we do need is awareness of our rights. Can I refuse? Can I do something about what's happening to me? If someone comes and asks for my phone, what are my rights? We have all seen what happened in Chennai. We have had several reports at sflc.in where Telangana police is just stopping randomly young people and saying, we are going to take your phones away. There several folks were alarmed when WhatsApp messages started leaking from various TV actors or celebrities, but this can also happen to all of us. Anyone who has driven in the streets of India, stopped on a traffic police stop or by random police people, asked questions, who you are with, what you are doing, etc., know what we all face. That's why this guide is based mostly on infographics. If you would see, it's simple to understand. It's easy. It asks the questions if they have been served, what their rights, what they need to do, when to ask what questions you're going to ask the police, what information will you take, how are you going to follow up. Of course, there are lawyers. Of course, there are us in terms of offering help. But as we had pointed out in the discussion earlier, if Ram Ramaswamy was filed in 2022, Prabir was arrested in 2023, and we're still seeing a lot of this happening. And at the pace technology is moving, we are obviously not catching up. Then we do have to ensure that at least the public knows what their rights are. SFLC works to defend digital rights and works on behalf of the civil society. That's why we're putting out this guide. Here's the QR code. You can look at it. It's a digital guide. It will be released in several languages. The first 6 tranches, of course, English, Malayalam, Hindi, Tamil, Bengali, Gujarati, and Marathi. And then we will continue to put it out in snippets, whether it is WhatsApp forwards or it is on your social media feeds, etc. Please take a look at it. Please share it. Please please figure out what the rights are as we continue the fight on various matters and rights in the courts. We will fight for those as well with all of yours help and as a network. But until that happens, at least awareness is the key issue. And that's why we are launching this. So please take a look, and thank you all for your time. I at least always learn a lot, and I'm very grateful that all of you decided to spend some time here.
Thank you, Mishi. As we are at the end of the session, I would, and we are well over time, I would thank all participants who have joined us for the session today. I hope that this guide helps in generating more awareness about the process, the legal measures one can take to protect their fundamental rights, and the technological measures to safeguard one's own data and devices. Thank you again to our esteemed panel of speakers who chose to take time out of their busy schedules and talk about this topic. Finally, I thank the entire SFLC.in team for their passion and hard work in producing this guide. Thank you. Goodbye, everyone. We hope to see you all again soon as we will continue to foster such essential conversations on various facets of digital rights and tech policy. Goodbye.
Thank you.